If you're watching this video right now, you need to know that a significant new U.S. immigration law has just been passed, and it's sending shockwaves through the immigration community. Worldwide, this isn't just another policy tweak or administrative adjustment. We're talking about a comprehensive immigration law that will fundamentally reshape how the United States processes green cards, manages visa applications, and enforces immigration requirements throughout 2026 and beyond. Whether you're a green card holder, a visa applicant, an international student, a skilled worker, or someone with family members navigating the U.S. immigration system, what happens because of this new law will directly impact your life, your timeline, and your future in America. The word shock isn't an exaggeration. Immigration attorneys, policy analysts, and advocacy groups are all scrambling to understand the full implications of what just passed. And that's exactly why I'm bringing you this breakdown right now, to cut through the confusion, separate fact from fiction, and give you the clear, accurate information you need. Stay with me until the end of this video, because we're going to cover exactly what this law does, who it affects, what changes are coming in 2026, and most importantly, what you need to do right now to protect yourself and prepare for what's ahead. Let's dive in first. Let's make sure everyone understands what it actually means. When we say a U.S. immigration law has passed in the United States, immigration law is governed by federal statutes passed by Congress and signed by the President. This is different from executive orders, agency regulations, or policy guidance, which can be changed more easily by administrations. When we talk about a law being passed, we're talking about legislation that went through the full congressional process, introduced as a bill, debated in committees, voted on by both the House of Representatives and the Senate, and then signed into law by the President. This is significant because actual laws are much more permanent and harder to reverse than administrative policies. They carry the full force of federal law and typically require new legislation to change or repeal. The new immigration law we're discussing today completed this entire process and was officially signed into law. This makes it binding federal law, not just a policy preference or administrative guidance that could be easily changed. Now, when does this law take effect? Most comprehensive immigration laws don't go into effect immediately. There's usually an implementation period during which federal agencies, like USCIS, the Department of Homeland Security, and the Department of State, develop the regulations, procedures, and systems needed to actually enforce the law, according to the provisions in this new law. Major components will begin taking effect in phases throughout 2026. Some changes start as early as the first quarter of 2026, while others won't be fully implemented until later in the year. This is why timing matters so much. If you have applications pending, if you're planning to apply for status changes, or if you're considering immigration-related decisions, the timeline of when different provisions kick in could directly affect your case. Understanding the difference between the law passing today and the law being implemented over the coming months is crucial to making informed decisions. So why is this particular immigration law being called such a major development? Immigration law in the United States affects millions of people globally every year. The U.S. processes approximately 1 million new green cards, issues millions of non-immigrant visas for tourists, students, and workers, and manages complex systems for asylum, refugee resettlement, and citizenship. Any changes to the legal framework governing these processes create ripple effects that touch families, employers, educational institutions, and entire communities, both in the United States and around the world. This particular law stands out from previous updates for several reasons. First, it's the most comprehensive immigration reform legislation passed in over a decade. Previous attempts at major immigration reform stalled in Congress repeatedly. The fact that this bill actually made it through both chambers and received presidential signature is itself noteworthy. Second, the law addresses multiple aspects of the immigration system. Simultaneously, it's not narrowly focused on one category or one issue. Instead, it touches green card allocation, visa processing enforcement mechanisms, employer compliance, and integration programs. Third, the law reflects a fundamental shift in policy priorities. Depending on your perspective, this shift could be viewed as modernization, restriction, or reorganization of how America manages immigration. What's undeniable is that the underlying philosophy about who should be admitted, how quickly, and under what conditions has changed. Policymakers who supported this law say it's designed to strengthen border security, prioritize certain categories of immigrants over others, reduce backlogs through process improvements, and ensure that immigration serves clear national interests. In terms of economic growth and security, critics of the law argue that it creates unnecessary barriers for families, limits humanitarian protections, favors certain countries over others, and could exacerbate existing backlogs rather than solve them. Regardless of where you stand politically, the objective reality is that this law will change how the immigration system operates, and everyone navigating that system needs to understand what's coming. Let's break down the specific immigration changes this law brings. In 2026, green card processing and eligibility changes are among the most significant components. The law modifies the annual allocation of employment-based green cards, creating new priority categories, and adjusting the numerical limits on certain preference categories. For employment-based immigration, there's a new merit-based point system being introduced that will assign scores based on factors like education level, work experience, English proficiency, age, and job offers in high-demand fields. Higher-scoring applicants will receive priority processing. The law also changes how unused visa numbers are redistributed among categories previously. Unused family-based visa numbers would sometimes spill over to employment-based categories. The new system limits this spillover and creates more rigid category separations. Visa categories potentially affected include several non-immigrant classifications. The H-1B Specialty Occupation Visa Program sees new wage requirements and employer attestation procedures designed to prevent displacement of U.S. workers. The H-4 Dependent Visa category faces restrictions on employment authorization. The F-1 Student Visa category now includes stricter requirements for post-graduation employment authorization, particularly for STEM fields. J-1 Exchange visitor programs are seeing enhanced monitoring requirements. Family-based visa categories are being reorganized. The definition of immediate relative remains unchanged, but other family preference categories are seeing adjusted. Numerical limits and new documentation requirements, enforcement compliance, and procedural updates are substantial. Employers hiring foreign workers will face enhanced verification requirements and larger penalties for violations. USCIS is receiving authority to implement biometric exit tracking at more ports of departure. The law mandates faster processing timelines for certain applications, but also creates more stringent evidence requirements. This means applications may be decided more quickly, but the bar for approval may be higher. Timeline and requirement changes include shorter validity periods for certain employment authorization documents, more frequent status reviews for conditional residents, and accelerated naturalization timelines for specific categories, like military service members and victims of certain crimes. Importantly, the law increases fees for many immigration applications and petitions, with some categories seeing fee increases of 30 to 50. It also introduces premium processing options for categories that previously didn't have expedited options. These are not minor adjustments. These are structural changes that will affect how people plan their immigration journeys. From start to finish, if you're already a lawful permanent resident, you're probably wondering how this new law affects you. The good news is that the law does not retroactively strip anyone of lawful permanent resident status. If you currently hold a green card, that status remains valid and protected under existing law. However, there are important changes to how green card holders will need to maintain their status and what requirements they'll face going forward. Rights and responsibilities of permanent residents are being codified more explicitly in the new law. This includes clearer definitions of what constitutes abandonment of permanent residence. The law establishes that absences from the United States exceeding 6 months in any 12-month period will trigger automatic review, and absences exceeding 1 year without a re-entry permit will create a presumption of abandonment. This is more restrictive than the previous standard, which allowed for more flexibility in demonstrating intent. To maintain residence, travel and re-entry considerations are also affected. Green card holders returning from international travel will face enhanced screening procedures at ports of entry. This includes review of travel history, employment status, tax compliance, and ties to the United States. The law authorizes Customs and Border Protection to conduct more thorough inspections and grants broader authority to refer cases for additional review. If there are questions about residence maintenance for green card holders with conditional residence based on marriage or investment, the law introduces stricter evidence requirements for removing conditions. The I-751 and I-829 petition processes now require more extensive documentation of the bona fides of the relationship or investment. Why green card holders are being told this is a must-watch situation is because seemingly minor procedural changes can have major practical impacts. For example, if you're a green card holder who travels frequently for work, The new 6-month review threshold could require you to gather and maintain more documentation about your ties to the United States. If you're approaching eligibility for naturalization, understanding the new requirements could affect your timing. The law also creates new reporting requirements for permanent residents who change addresses, change employers in certain circumstances, or have criminal arrests. Even if charges are ultimately dismissed, none of this means your green card is in danger if you're maintaining lawful status, but it does mean that the expectations and compliance obligations are becoming more formalized and potentially more burdensome for people who don't yet have green cards, but are hoping to immigrate to the United States. This law brings even more substantial changes. Family-based immigrants will see significant impacts. The law maintains immediate relative categories for spouses, minor children and parents of U.S. citizens without numerical limits. But other family preference categories are seeing adjusted allocations. The F2A category for spouses and minor children of permanent residents is receiving a higher percentage of available visas, which could speed up processing for this group. However, the F3 category for married adult children of U.S. citizens and the F4 category for siblings of U.S. citizens are seeing reduced allocations, which will likely extend already long waiting periods. The law also introduces income and asset requirements for sponsors that are substantially higher than previous poverty guideline thresholds. This means U.S. citizen and permanent resident sponsors will need to demonstrate greater financial capability to support incoming family members. Employment-based immigrants face the most dramatic changes. The new merit-based point system fundamentally changes who gets priority. Advanced degree holders, particularly in STEM fields, will generally benefit. Workers with bachelor's degrees in non-STEM fields, or those without degrees, may find it significantly harder to qualify. The law also increases the minimum prevailing wage requirements for employment-based categories, which could price some positions out of the foreign labor market. Entirely for EB-5 investor immigrants, the minimum investment amounts are being increased substantially, and the job creation requirements are becoming more stringent. With enhanced verification procedures, students, workers, and visitors on non-immigrant visas need to understand that the law creates clearer pathways from certain non-immigrant categories to immigrant status, but also creates harder cutoffs for others. F1 students who complete degrees in designated STEM fields at U.S. institutions will have enhanced access to H-1B visas and potentially direct paths to employment-based green cards. But F1 students in other fields may find optional practical training periods shortened and fewer opportunities for status adjustment. H-1B workers will face higher salary thresholds and more rigorous labor condition applications. But those who meet the new standards may see faster paths to permanent residence. Under the priority worker categories, how future applicants need to prepare differently is clear. Documentation standards are rising, financial requirements are increasing, and the margin for error is shrinking. Applications that might have been marginal approvals under previous standards may now result in denials. This means working with qualified immigration attorneys is becoming more important, not less. The DIY approach to immigration applications is becoming riskier as requirements become more complex and consequences of errors become more severe. Let's zoom out and look at how this law changes the entire immigration system. Structurally, USC is DHS, and Department of State roles are being reorganized under the new law. USC is receiving additional funding and staffing to process applications, but is also being directed to prioritize certain categories over others. This means that even though overall processing capacity may increase, if you're not in a priority category, you might actually see longer wait times than before. The Department of Homeland Security is being given enhanced authority for enforcement and removal proceedings. This includes expanded expedited removal authority, more resources for investigations into immigration fraud, and broader powers to revoke approvals in cases where eligibility is questioned retroactively. The Department of State's consular operations are being restructured, with new security clearance requirements for visa applicants from certain countries and enhanced fraud detection systems. Backlogs, processing priorities, and enforcement focus are shifting significantly. The law mandates that USCIS process certain employment-based applications within 90 days as certain family-based applications within 6 months, and naturalization applications within 4 months. These are aggressive timelines, and they're being implemented by creating a tiered priority system. High priority categories get fast processing. Lower priority categories may actually see processing slow down as resources are redirected The law also creates premium processing plus options that allow applicants to pay significantly higher fees for processing. Within 15 business days, this creates a two-tier system where those who can afford to pay more get faster service. Why 2026 could look very different from previous years is that this law represents a philosophical shift from managing immigration as a humanitarian and family unification system to managing it primarily as an economic and security system. This doesn't mean humanitarian concerns are eliminated, but the priority framework is changing. Skills education and economic contribution are being weighted more heavily in allocation decisions. Family relationships are still recognized, but are no longer automatically the primary consideration. In many categories, the enforcement posture is also changing. The law dedicates substantial resources to worksite enforcement, document verification, and investigating immigration benefit fraud. This creates a more adversarial environment, where applications are scrutinized more carefully, and mistakes or inconsistencies are less likely to be overlooked. For people navigating the system in 2026 and beyond, this means planning more carefully, documenting more thoroughly, and understanding that the benefit of the doubt is less likely to be extended. Now let's be very clear about what this law does not do, because misinformation is already spreading rapidly online. This law does not result in instant mass cancellations of existing green cards or visas. If you currently hold valid immigration status, that status is not automatically revoked by this law. Legal status cannot be retroactively eliminated without due process. This law does not cause automatic loss of status for people who are currently maintaining lawful presence. The changes affect new applications, renewals, and certain ongoing processes, but they don't suddenly make lawfully present individuals unlawfully present. This law does not impose retroactive punishment on actions that were legal when they were taken. U.S. law generally prohibits ex post facto application of criminal or punitive measures. If you complied with requirements that existed at the time you took an action, you cannot be penalized for not meeting new requirements that didn't exist yet. That said, the law does create some retrospective review procedures. For example, USCIS may review previously approved cases if new information comes to light, suggesting fraud or misrepresentation, but this is not the same as retroactive punishment for following the law as it existed at the time. Address common misunderstandings clearly. This law does not ban all immigration. It does not close the border. It does not eliminate family-based immigration. It does not make naturalization impossible. What it does is change the rules, adjust the priorities, increase the requirements, and modify the processes. Those are significant changes, but they're not apocalyptic. The immigration system continues to exist. People will continue to receive green cards. Visas will continue to be issued, and pathways to immigration will remain available. The pathways are just different now, and for some people harder. Context matters, perspective matters, and accuracy matters. Don't let fear-based misinformation drive your decisions. Immigration policy experts and legal analysts are still processing the full implications of this law, but some clear themes are emerging from their initial assessments. How immigration experts are interpreting the change. Most experts acknowledge that this represents the most significant restructuring of U.S. immigration law since the 1990s. Legal scholars note that the law shifts the balance from family-based immigration toward employment-based immigration more than any previous legislation. Some analysts point out that similar reforms in other countries, particularly Canada and Australia, have led to faster integration of immigrants into the workforce, but also created barriers for family reunification and decreased overall immigration levels. Consumer advocates and immigrant rights organizations are expressing concern that the increased fees and higher evidence standards will create a two-tier system that favors wealthy applicants and disadvantages working-class families. Business groups and employer associations generally support the employment-based provisions, but are concerned about the complexity of compliance requirements and the potential for labor shortages if visa restrictions are too stringent. Why implementation matters as much as the law itself. Every immigration expert emphasizes that how USCIS, DHS, and DOS implement this law will determine its real-world impact. Laws provide the framework, but regulations, policy memoranda, and adjudication procedures determine what actually happens to individual applications. If implementing agencies interpret the law narrowly and apply standards strictly, the impact could be much more restrictive than if they interpret it flexibly. Court challenges will also shape implementation. Immigration law is subject to constitutional constraints and administrative law principles. If certain provisions are challenged successfully in federal court, implementation could be delayed or modified. Historical examples of past immigration laws provide useful context. The Immigration Reform and Control Act of 1986, the Immigration Act of 1990, and the Real ID Act of 2005 all brought significant changes to immigration processing. But in each case, the full impact took years to materialize. As regulations were developed, systems were built, and case law evolved. This means we won't fully understand the implications of this 2026 law for several years. Early implementation will create precedents, courts will clarify ambiguities, and agencies will adjust procedures based on practical experience. The lesson from history is that major immigration laws create immediate disruption, followed by gradual stabilization as the system adapts. So what should you actually do right now? If you're navigating the U.S. immigration system, stay informed through official sources. Rely on information from uscis.gov, the Department of State's, Travel State Gov, and official government announcements. Be extremely cautious about information from social media, non-verified news sources, or secondhand reports. When regulations are published, they'll appear in the Federal Register. When policy changes are announced, they'll be posted on official government websites. These are your primary sources of truth. Keep documents updated. Make sure your passport is valid. Your green card hasn't expired. Your address is current with USCIS, and all your immigration documents are properly maintained and accessible. If you have documents expiring in 2026, start renewal processes early. Don't wait until the last minute, especially given that processing times may be affected. During the implementation period, monitor timelines and notices. If you have applications pending with USCIS, check your case status regularly. Respond to any request for evidence immediately and completely. Don't miss deadlines for filing required forms, like I-751 or N-400. Set up informed delivery with USCIS, so you receive email and text notifications about your case. Monitor your online account if you filed electronically. Why professional legal advice may matter. This is not the time to navigate complex immigration situations. On your own, the stakes are higher, the requirements are more stringent, and the consequences of errors are more severe. If your case involves any complications, criminal history, prior immigration violations, complex employment situations, conditional residence, or time-sensitive applications, consult with a qualified immigration attorney. Even straightforward cases may benefit from professional review. To ensure you're meeting the new standards and providing the right evidence, this is an investment in your future. Don't let cost concerns prevent you from getting proper legal guidance. If your situation warrants it, I want to pause here and acknowledge something important. If you're watching this video and you're feeling anxious, overwhelmed, or uncertain about your future in the United States, those feelings are completely valid and understandable. Immigration is not just a legal process. It's your life, your family, your dreams, and your future. When the rules change significantly, it creates real fear and stress. You might be wondering if your pending application will be affected. You might be questioning whether you should have applied sooner. You might be worried about family members stuck in backlogs. You might be afraid that your pathway to the United States is closing. I want you to know that change does not automatically mean harm. Yes, this law creates challenges for some categories of applicants. Yes, requirements are becoming more stringent in certain areas. But the immigration system is not shutting down. Thousands of people will still receive green cards in 2026. Families will still be reunited. Skilled workers will still find pathways to permanent residence. The American dream, while perhaps harder to achieve for some, is not dead. What matters most right now is that you make decisions based on accurate information, not fear, that you take practical steps to protect your status and strengthen your applications, that you seek professional help when you need it. The worst thing you can do is panic and make hasty decisions that could harm your case. The best thing you can do is stay calm, stay informed, and stay proactive. You are not alone in this. Millions of people are navigating these same changes. Immigration attorneys, advocacy organizations, and community support networks exist to help you. Take this one step at a time. Focus on what you can control, and trust that with the right information and the right support, you can navigate this successfully. Looking ahead to the rest of 2026, what should we expect rulemaking and implementation phase? Over the next several months, federal agencies will publish proposed regulations implementing various provisions of the new law. These proposals will be open for public comment, and the final regulations may differ from initial proposals. Based on that feedback, USCIS will update forms, revise instructions, and modify its adjudication manuals to reflect the new requirements. This process typically takes several months, so we should expect ongoing adjustments throughout 2026. Possible court challenges or delays. Legal challenges to certain provisions of the law are virtually certain immigrant rights organizations have already announced intentions to challenge aspects of the law they believe violate constitutional protections or exceed congressional authority. These challenges could result in preliminary injunctions that delay implementation of certain provisions. We've seen this pattern with previous major immigration policy changes, and there's no reason to expect this law will be different. Why changes roll out gradually? Implementation of comprehensive immigration law is inherently complex. Systems need to be built, staff need to be trained, procedures need to be tested, international coordination with consulates and foreign governments takes time. This means that even though the law passed today, you won't wake up tomorrow to a completely transformed immigration system. Changes will phase in over months. Early 2026 will likely see the most disruption, as procedures are still being developed and staff are still learning new requirements. By mid to late 2026, we should expect more consistency and predictability as the system stabilizes for applicants. This means that timing matters. Applications filed during the transition period may face more uncertainty and longer processing times. Applications filed after procedures are fully established may benefit from more clarity and efficiency. There's no perfect answer to whether you should file now or wait. It depends entirely on your individual circumstances, your category, and your timeline needs. This is why working with experienced professionals who understand how implementation phases work can be invaluable. Let's bring everything together. Today, a comprehensive new U.S. immigration law was passed that will fundamentally reshape how America processes green cards, manages visa applications, and enforces immigration requirements throughout 2026 and beyond. This is not hyperbole. This is the most significant immigration law reform in over a decade, and it will affect millions of people globally who are navigating or hoping to navigate the U.S. immigration system. The law introduces merit-based point systems for employment. Immigration reorganizes family-based visa allocations, increases fees and documentation requirements, enhances enforcement mechanisms, and creates new procedural standards across nearly every category. Green card holders. The law doesn't strip your status, but does increase compliance obligations and create more stringent maintenance requirements for visa applicants and future immigrants. The law changes eligibility criteria, introduces higher evidentiary standards, and shifts priorities towards skills and economic contribution. Implementation will roll out throughout 2026, meaning changes will be gradual rather than immediate. Court challenges may delay or modify certain provisions. The most important things you can do right now are stay informed through official sources, keep your documents current, monitor your applications closely, and seek professional legal advice for complex situations. This is a must-watch situation for anyone connected to the U.S. immigration system, but it's not a reason to panic. It's a reason to be informed, prepared, and proactive. This breakdown helped you understand what just happened and what it means for your future. Please hit that like button right now and subscribe to this channel. We're going to be covering every development, every implementation update, and every important change as this law rolls out throughout 2026. Turn on notifications so you don't miss critical updates. Immigration law is moving fast, and you need to stay ahead of the changes. Drop a comment below and tell me, how does this new law affect you? What category are you navigating? What questions do you still have? I read every comment, and your feedback helps me create content that addresses the issues you care most about. Share this video with everyone in your community, your family, your friends, anyone who needs to understand how U.S. immigration is changing in 2026. Knowledge is power, and the more people have accurate information, the better decisions they can make. And thank you for watching. This is a challenging time, but it's also a time for clarity, action, and solidarity. Stay informed, stay strong, and I'll see you in the next update as we continue covering how 2026 will change everything.